Pretty shocking to get a preference lawsuit that demands you pay back money that was rightfully paid to you for providing a product or service. For example, you sell machines to Acme Inc. Acme pays you the agreed upon price. There are no complaints. Now, almost 2 years later, you get sued by a bankruptcy trustee who says he wants the money back. Under the preference laws, the trustee adds that while you have to return the money, Acme, now in bankruptcy, will keep the machinery. Sounds like it just doesn't make any sense. There is a rationale for the preference laws. The theory is that the company was insolvent when it paid you in full. It did not have the money to pay all creditors in full. If the company paid you in full and others later get paid 3 cents on the dollar in the bankruptcy, you obviously get a much higher percentage distribution. Other creditors are actually paid less money on a percentage basis since you were paid more than your fair share prior to the bankruptcy. The first question is, why is distribution to other creditors my problem? In the normal course of affairs, it's none of your concern whether other folks are getting paid. However, in a bankruptcy situation, it becomes an issue. Why? Because the debtor owes more than it can pay. Bankruptcy creates a unique legal environment where equitable distribution to creditors is a primary concern. An equitable distribution means dividing up an asset pie fairly so each creditor gets paid the same percentage of their claim. If you get paid 100 cents on the dollar right before bankruptcy and everybody else is later getting 3 cents on the dollar, that's not a fair distribution of the pie. What if a company paid out all of its money to you or a few favorite creditors and then there was no money left to distribute to anybody else? The whole purpose of the bankruptcy laws, to cut up a limited asset pie fairly, would be completely defeated. The preference laws are designed to discourage creditors from aggressively pursuing preferential payments, as in the above example. The theory is that since creditors know they will have to return the money, they will not pursue aggressive collection activity. While it's clearly unfair to force the return of money properly paid to creditors, Congress decided that it's more important to protect the theory of equitable distribution during the bankruptcy process. To balance out a little bit of the harshness of the preference clawback laws, Congress provided for substantial defenses that are usually available to the defendant. The first reaction of almost all defendants is that neither themselves or the debtor tried or intended to engineer any kind of a preference. I didn't get a preference. I wasn't preferred. I have no relatives over there. I didn't know anyone over there. I just got a check in the mail. It's important to understand that if you got paid 100 cents on the dollar at a time when the company, if it paid everyone, had only the assets to pay each creditor 3 cents on the dollar, then you were preferred. Whether the company intended to prefer you or whether you acted to be preferred does not change the fact that you were, in fact, preferred when the debtor was insolvent. Despite the fact that you may have been preferred, it still feels very harsh to force a creditor to pay back money when that creditor obviously was properly paid and provided a valuable product or service. In the early days, the courts tried to be fair by only clawing back money from creditors who seemed to act in bad faith. The law distinguished between bad and good creditors. Bad creditors knew there would be a bankruptcy filing and willfully conspired with the debtor to get paid in full, knowing the debtor would not be able to pay its debts to other creditors. Good creditors, on the other hand, were clueless as to any bankruptcy and tried to get a check in the mail. They got a big slice of the pie, but not on purpose, by accident. After 1978, the bankruptcy laws changed. Trustees no longer had to prove bad intent. Why? Because it was too hard, and they weren't clawing back any money. So making the trustees show that you were a bad creditor or trying to show that you were a good creditor doesn't work anymore. But defendants have defenses that track the original concept. The law is confusing because you cannot prove that you were a good creditor or that you weren't preferred. Yet the law still incorporates the concepts of a bad faith creditor versus an innocent accidental preference recipient. Essentially, the preference laws give good faith preference recipients the opportunity to show good faith not by direct testimony, but rather by circumstantial evidence. Since the defenses are generally not proof that there was no preference, but rather an equitable safe harbor. Since these defendants generally do not prove that there was no preference, but rather serve as an equitable safe harbor, I call these defenses guilty with an explanation.